Hey everyone, this is Mike DeBliss. This podcast episode is called Let's Make a Deal, Buying or Selling a Screenplay. This is actually a fascinating field of intellectual property. It's one that appeals to me on several levels, not only as an attorney who is very curious about intellectual property, but also as an artist, as an actor. I also recognize that it's a very complicated area, and it's very easy to lose people in the minutia. So I think the best way to back our way into this is by starting out with some basic things that might be a little elementary, and then use those as the building blocks to get into some more complicated concepts. So I hope that this will add value to both the beginner filmmaker as well as the advanced filmmaker. As a way, and the way I structured this was in a Q&A format. So what I'm going to essentially do is just go through a number of questions and then provide some answers. And as we go through this, as issues arise and as things come to mind, I might elaborate more on my answers. So the first question is, what is the initial step in developing a motion picture? And just to back up, by motion picture, what I'm referring to here is a feature film, new media, television movies, television series, or subscription videos on demand. The initial step in developing a motion picture usually requires the acquisition of rights to the screenplay or an underlying property. By underlying property, I'm referring to a book, a novel, a stage play, a video game, you name it. And the underlying property is usually what the screenplay is based on. So it's very important to recognize that there might be two levels in basically in developing your motion picture and acquiring the rights that are necessary to develop the motion picture, because it may not just be the screenplay, but it may be the book, the novel, or the stage play upon which the screenplay is based. So when it comes to acquiring the rights, it's very important to know whether you're dealing with just a screenplay or you're dealing with the screenplay that's been based on a book or a novel. Second question, who are the purchasers of screenplays? They're producers, studios, networks, or production companies. 3. Why would a filmmaker want to acquire the rights to a screenplay from the screenwriter or owner of the literary property? I realize that this sounds very basic and elementary, but just to basically fill it out, when the filmmaker decides not to write the script himself or hire a writer to write it, that's usually when the filmmaker will acquire the rights to the screenplay. So the acquisition of rights to a screenplay usually arises in situations when the filmmaker decides not to write the script himself or to hire a writer. 4. Why does an indie producer, a financier, or studio prefer to acquire an option from the screenwriter or owner of the literary property rather than purchase the screenplay outright? Now this raises the whole issue of option agreements, and what the thrust of this question is getting at is, why is the indie producer or why does the indie producer prefer to acquire an option from the screenwriter or owner of the literary work instead of purchasing this screenplay outright? Well, option agreements serve a useful purpose, especially for indie producers who may not necessarily have the financial wherewithal to pay for the screenplay outright. And normally the amount paid for the option is a fraction of the price that would otherwise be paid to buy the screenplay outright. And so that's what makes an option an enticing way of acquiring rights to the screenplay. As you can imagine, the purchase price for purchasing the screenplay outright could be absolutely staggering, but when it comes to purchasing, or rather acquiring, an option from the screenwriter, that could be that figure is usually a lot less expensive than purchasing the screenplay outright. And options are usually a fraction of the price that would otherwise be paid to purchase a screenplay outright. Number 5, what two forms does an option agreement come in? And now we're going to get into some technical things. There are actually two forms that an option agreement comes in. The first is the purchase of the right to buy the screenplay, and that's what's referred to as the option. And the second is the agreement for the sale of the screenplay that comes into effect upon the exercise of the option, and that's what's referred to as the purchase. 6. What benefits does an option agreement afford a producer or studio? Well, an option allows the producer or studio the exclusive, irrevocable right to purchase a screenplay at a set price within a specified period of time. That specified period of time is usually referred to as the option period. An option enables the producer or studio to undertake development activities, seek to attach talent in the form of actors and other individuals that are necessary to produce the film, and other elements such as securing financing without having to incur the full expense of the purchase price for the script up front. So it basically is giving the studio the exclusive, irrevocable right to purchase a screenplay at a set price within a specified period of time. At the same time, the option enables the producer or studio the time it needs to undertake development activities and to get the actors in line, to get the other necessary workers in line to actually produce the film. And again, this is all happening without the necessity of incurring the full expense of purchasing the price outright and upfront. Why does the owner of a script rather sell it instead of have it optioned? Again, this could be viewed as being very straightforward and elementary, but at the same time it's worth mentioning. In most cases, the owner of a script prefers to have it purchased outright rather than optioned because they'll receive a greater payment up front. What's interesting, however, is that some owners of the script actually prefer options because it allows them, it allows certain incentives to come into play as the film is being created. And so, for example, a script that might not have a lot of promise or might be viewed as being lackluster at the beginning might show more promise during the development stage, and that's when things might just blow up for the script and for the film. And in that case, the screenwriter gets to see that his script is worth a lot more than what he thought it was worth at the outset, and so that could allow for enhanced bargaining and for more leverage later on. And so there are some script writers who prefer to the option route as opposed to selling the script outright, because options could allow incentives and could allow very enticing marketing agreements later on down the line. And so the savvy screenwriter might just prefer to sit back and see how the filmmaker brings this script into the world and how he or she creates it, and what type of reaction the public has to it, and all of that could lead to lucrative marketing deals down the way or down the line that might not have been imagined at the outset. What type of agreement is used if the producer or studio does not bother with an option but instead immediately purchases a script? A literary purchase agreement is used in those cases where the producer or studio doesn't bother with an option but instead immediately purchases a script. Again, it's called an LPA, or a literary purchase agreement. How does the literary purchase agreement impact the provisions of the agreement? Well, if we're talking about the Writers Guild of America Basic Agreement, if that's the one that applies, then the provisions of the Basic Agreement provide minimum guarantees and minimum guidelines for the purchase price, option fee, option period, writing services, and representations and warranties. However, if the Writers Guild of America Basic Agreement doesn't apply, the parties can still elect to use certain provisions from the WGA agreement to provide the minimums for their agreement, or what we might otherwise refer to as the floor for the agreement. When optioning an original screenplay, who is the filmmaker buyer dealing with? Usually it's just one person, and that's the copyright owner. Now contrast that to when optioning a screenplay that is an adaptation of a previously existing artistic work, like a novel. The question that arises here is, must the filmmaker ensure that he or she is also getting the option for the underlying literary material? I touched on this a little bit earlier. Absolutely, 100% yes. So whenever there is optioning of a screenplay that's based on a previously existing material, such as a book or a novel, the filmmaker must ensure that he's also getting the option for the underlying creative work, that being the novel or the book. And so the right to make a film based on a script that is based on a novel will necessitate obtaining the right to make the novel into a film. And so you can't overlook the fact that acquiring the rights to the novel is just as important, if not more important, than the screenplay. And failure to do so could run afoul of a number of copyright laws and could make you a defendant in a nasty litigation. Now, whether a filmmaker is producing the film or selling the script or both, what is the process like? Well, it's almost like having a startup company, like an initial public offering. The filmmaker's first task is to select and form a business entity for optioning, and then selling or producing the script, such as a limited partnership, limited liability company, or a corporation. The type of business entity that's formed can have a huge impact in determining the success of the film, as well as have as having an impact on the filmmaker's exit strategy. So it's very important when this idea is in its infancy to think about the type of entity that is going to be organized and to treat this as if it's an initial public offering, because it's a big deal. Even if we're talking about simply an indie film, you have no idea at the outset how successful the film is going to be, whether they're going to be branding rights further on down the line, whether there could be commercial deals that are structured with with companies like Hasbro or what have you to turn out a line of some type of dolls or action figures or something along those lines. So you have to dot all your I's and cross all your T's up front to ensure that everything is done professionally and in a fashion that would allow branding to come into play later on if the film is a huge success. Now, what are the essential terms of an option agreement? I'm going to list them. We're going to talk about them in a later podcast episode just because they do get technical and nuanced. There are at least a dozen of them here. The first essential term of an option agreement is what's called a condition precedent. The second basically is option versus outright purchase. The third is setup bonus. The fourth is purchase price. The fifth is credits. The sixth is rights conveyed. The seventh is rights reserved. The eighth is the holdback period. The ninth is writing services and fees. The 10th is warranties and indemnities. The 11th is subsequent production. The 12th is reversion and turnout right. The 13th is consultation and approval rights. The 14th is assignment. And the 15th one is signatures. And as I said, I'll cover these various essential terms in the next podcast episode. But for now, that will end episode 1. And if you have any questions, feel free to shoot me an email at mjdebliss@deblisslaw.com. I've also put up some really insightful blog posts on this topic on my blog that's located on my website at deblisslaw.com. You can find it on the Tax Chat blog, and there's a number of blogs that touch on this and other issues that relate to producing indie films, and that talk about the various platforms that are available to the indie filmmaker, as well as this topic directly. So I welcome you to check out those blog posts.